Alex here with a legal nuts and bolts video on writ petitions. This one I've been holding off for the longest time because I knew it was going to be technical, but over and over again people are asking for this video, so I'm going to go ahead and do it. I'm going to cover it as best I can, and if anyone has any trouble, you're going to just have to look at case law to understand exactly what I'm talking about, and even then it might not make any sense. A writ petition, or a petition for an extraordinary writ, is, in a nutshell, a backup plan. It's the best way I can describe it. There are areas in the law where you are entitled to a certain thing, whether it's because of the Constitution or because of some statute, and you have no legal remedy available to you. You have no proper mechanism by which to bring that issue and get what you are entitled to the court. And what you are able to do in these cases is file a writ petition, a petition for some kind of extraordinary relief. There's a lot to how these work. I explain some of how they work in my video Filing an Appeal, and I think I explained a little bit of it in Standard of Review, because you can use writ petitions for more than just this, but mainly they're used to challenge a judge's order or refusal to enter an order when you can't appeal it. That's one of the biggest reasons that they're used. You can file appeals in cases only under certain strict circumstances, and sometimes, oftentimes, usually lawyers file it. Non-lawyers usually don't even know what it is. They'll need to bring an issue to a higher court's attention to force the judge to either grant something that they didn't grant or deny something that they granted that they could not otherwise appeal. And some people find this odd. A lot of people think you can appeal anything, and you can't appeal anything. I'm not going to go into the details on this. It's in Filing an Appeal, in Standard of Review, where I explain exactly what it is, or not exactly what it is, but I give some kind of guidelines on what sort of statutes and rules might apply as to whether or not you can file an appeal. But anyway, going back to what I was saying, most of the time writ petitions are filed because an appeal is not allowed. And it naturally and logically follows that if you can't appeal an issue and it needs to be addressed, then your only way of doing so is by writ petition. But going a little bit further back into what I was talking about, I did say that they're not just used for that. They're also used to sue, like, government actors. For example, I filed a writ petition, and I was published under Falcone v. Secretary of State. And I didn't sue a judge. I sued the Secretary of State. And I argued that the Secretary of State, it's a government actor, I argued that the Secretary of State was not following the law with regards to how the confidential address program was supposed to work. And I relied on the statutes. And one of the issues that I brought to the Supreme Court's attention, Supreme Court of Nevada, was that I could not appeal their determination, which I couldn't. And I found this out the hard way, because I tried to appeal it in a different case, and the Supreme Court said that the process that my ex used to get a fictitious address from the confidential address program was not appealable, or was not challengeable using the mechanism that I tried to use, and thus not appealable because I was wrong by using the mechanism that I did. It's a little bit complicated, but anyway, the point is that there was no ordinary remedy, or adequate legal remedy is what they call it, available to me to get the Secretary of State to do what they were supposed to do. So I had to use the petition for writ of Mandamus, which is one of the several different types of extraordinary writs out there. Again, this is an example where I didn't use it against a judge. I used it against a government actor that I could not challenge using any adequate legal process. I was basically forced to use what I mentioned at the beginning of the video is, in a nutshell, a backup plan, a sort of fallback for you to get access to the courts where you otherwise would not have the access that you're entitled to have. Let's see here. I'll go over the different types later. I wanted to bring up some examples of how writ petitions are used to challenge judges, which is, it ends up being the most often way that they're used. For example, somebody might file a motion to dismiss a lawsuit, and the judge denies the motion to dismiss. Well, can you appeal it? You would think that you can, but you can't, because in Nevada, you can't appeal an order unless, and there's some exceptions to this, unless the case is completely closed and the final judgment has been entered. An order denying a motion to dismiss does not end the case. The case is still open, so it's not an appealable order. Ironically, if the judge had granted it, if the judge had granted the motion to dismiss, the case would be closed, and thus you would be able to appeal an order granting a motion to dismiss. And of course, I'm not mentioning all these little tiny details, so please don't just go off of what I'm saying, because, for example, a judge could dismiss a case with respect to 2 defendants, but not the third, and then you would think you can appeal that based on what I just said, but you can't. Again, please do your own research. It's a lot more complicated than just what I'm saying. Or, I don't like the word complicated. It just takes a lot more work than to just go off of these anecdotal examples, anecdotal experiences and examples. Where was I? Yeah. So, and it's what I was going to say is it's also slightly unfair in a non-legal sense, because it's like if the judge grants that motion to dismiss, the losing party can appeal it, but if the judge denies it, the moving party can't. Again, this is an example of where somebody might try to use a writ petition, a petition for writ of Mandamus, to force the judge to grant the motion to dismiss because they weren't able to file an appeal. They had no other way to challenge it except by writ petition. Now, again, that sounds simple, but it's actually more complicated than that. There comes that word again. I warned you guys in the beginning of this video it wasn't going to be that easy. I suppose it helps just to know all of these little nooks and crannies, just so people actually are alarmed and look more in depth into this before they just try and do one of these on their own. It's not that simple in the sense that the way appeals work is completely different than the way writ petitions work. So an appeal, if you file it, it will be considered as long as the court has jurisdiction. How does the court not have jurisdiction? For example, if you waited too long to file a notice of appeal. But if you did everything properly, the court will consider you, the appellate court will consider your appeal, and they will render a decision stating that you were either right or you were wrong. Writ petitions, it's not that simple. Writ petitions, they might just not consider. They can do that. That doesn't mean you're wrong. It just means they decided it wasn't important enough, it wasn't a big enough deal. And they also have a whole slew of all kinds of extra standards and principles that they apply, even on top of that, that may preclude you from getting writ relief. So one of them, for example, is that you are trying to dismiss the case when there are factual issues that need to be considered by the lower court. Well, if there's no factual issues at all and it's purely legal, that implies that the Supreme Court will consider a writ petition forcing your judge to dismiss the case. But that's not for sure. And if there are factual issues, then the Supreme Court has indicated they won't even entertain your writ petition. This is just on motions to dismiss. Another example is summary judgment motions. If a court grants a summary judgment motion, the case is closed. Again, remember there's exceptions. So for example, if they grant summary judgment with respect to some issues but not all of them, then that order is appealable. But if the judge denies a motion for summary judgment, you can't appeal it because the case is still open. There's also, let's see, there's also times that people, actually, I think I'm going to stop there on the examples as to how judges, temporary orders. I'll mention that too. I've seen temporary orders challenged by a writ petition because I mentioned in my previous video, at least in Nevada, that temporary orders are not appealable. So does that mean you can't do anything about it? No, you could file a writ petition, but I did mention that they don't have to be considered. The Supreme Court can just say, you know, we've read this and whatever it is that you're suffering isn't a big enough deal that it warrants our attention. We have another 1,000 cases to look at. If this was more important, we would take it, but it's not important enough. You're not wrong, we're just not going to consider it. And they'll deny your writ petition. So I covered certain types of orders that you can't appeal. I covered temporary orders. There's other oddball cases where writ petitions are used where you're adversely affected in a way that is not connected to your case. So for example, in Nevada, if you're held in contempt of court, that doesn't affect your rights in your case with regards to what you're seeking in your custody case or in your lawsuit for money or whatever. But it does affect your personal rights as a human being because you're being fined or put in jail. So you may not be able to appeal it. Actually, for a time you were able to appeal these, but the Supreme Court a few years ago said that from now on they weren't taking any more appeals on contempt of court, being held in contempt of court. But you can file a petition for writ of mandamus and argue that the court violated the principles, the legal principles behind how contempt of court is supposed to work. So that's another example where, yeah, you can't file an appeal, but you can file a writ petition. Oh, another popular one is fee waivers. There's actually a statute in Nevada that says, you know, that articulates the circumstances under which you're supposed to get your fees waived. And in that statute, it specifically says that these cannot be appealed. Well, the funny thing is, just because it can't be appealed doesn't mean it can't be challenged. You can file a writ petition and have your judge forced to give you a form of pauper status and waive your fees. And that's actually something that the Supreme Court has done before quite often, I think. I know they published a pretty big case on it explaining that they could issue writ petitions because it was an equal protection issue under the Constitution, and because the statute didn't allow appeals, they were forced to hear it under a writ petition because there was no other way for somebody to challenge it. I'm trying to think of other issues or examples. This is tricky because they really are just an oddball remedy. It's not something that is supposed to be used all the time. They get denied frequently because people use them when they should have waited for an appeal, when they tried to bring issues that had too many facts or even any facts at all. And this, I think I mentioned in standard of review that the Supreme Court, at least in Nevada, does not want to hear fact-intensive cases. In fact, the only time that it could even come to them is under a original writ petition, which is a writ petition that's filed straight in their court. And my understanding is that they don't hear facts on those. They want you to file it in the district court first and then take it up to them and let the district court do all the fact finding. Trying to avoid going on tangents, but this is just one of those issues that's a spider web of principles and interconnected logic. I did say I was going to go into the different types of writ petitions, so I will go ahead and do that. I know about 5. There's probably more. Mandamus, prohibition, certiorari, habeas corpus, and I don't know if I'm pronouncing this last one right, but it's Quo Warranto. I'm not even going to talk about that one besides naming it. I'll put the spelling in the description below if you want to look that one up. But I will give you a little brief nutshell version of what each of these can do for you if you just to help people out. Of course, you're going to have to find the details out in your own case law. But mandamus is one of the more popular ones. I think the Latin root is mandate. It's also called the writ of mandate. You're trying to force a judge to do something that they, or not just a judge, force a judge or a government actor, state actor to do something that they are required or obligated to do under the law. I mentioned a few examples earlier where people use mandamus to force a judge to dismiss a case they refuse to dismiss, to enter summary judgment in a case they refuse to enter summary judgment, to, in my confidential address program, it was used to force the Secretary of State to turn over my ex's address. I'm not going to cover anything else on that. There's a few caveats with mandamus that you have to look into on your own, do your own research. Prohibition. The writ of prohibition is used to arrest or stop a proceeding that has been instituted, specifically because whoever is presiding over that proceeding does not have the jurisdiction to do so. I'm going to give just some really dumb common sense examples, but it hopefully will get the point across to you. Say, for example, that you were sued in justice court for child custody. The justice courts don't have jurisdiction to hear child custody cases. Well, your justice of the peace is dumb and won't close your case. You filed a motion to have it dismissed and they refuse to dismiss it. This is an issue where you're not even talking about the merits of the child custody or divorce. You're not even going into what's going on with the kids and the child support. You just are basically saying, shut this thing down. This guy doesn't have jurisdiction. And that's what the writ of prohibition is used for. You would go to the Supreme Court, or the district court actually, to be honest, because it's the next court up. They would review your petition for writ of prohibition. They would say, oh my God, the justice court doesn't have jurisdiction to do divorces or child custody, and they would most likely grant your petition for writ of prohibition, and they would send the justice of the peace a writ of prohibition that says, you need to close this case now and get off of it. It's basically what it says. It prohibits them. It says, stop what you're doing. You don't have the authority to even hear this. That's what writs of prohibition are used for. Writ of Certiorari is the writ of review. I'm sure this can be used in more ways, but the most popular way is to have, this is the most common, most popular way that I've seen certiorari used, and that is, and I may not be pronouncing it right, sorry if I'm not, that is to have an appeal that was just heard again by an even higher court. If you watch my video on appeals, I have two videos on appeals. I mentioned them already, filing an appeal and standard of review. You'll hear somewhere in those videos that I mention that one of the limits on appeals is that you only have a right to one appeal. So if you appeal a decision in the justice court to the district court, you cannot appeal that decision again from the district court to the Supreme Court. You're not allowed to do that. And so people wonder, well, how do cases get to the Supreme Court? Well, they get there by writ of certiorari. It's a writ petition, so it follows all the other principles that I mentioned on writ petitions. For example, the court doesn't have to hear it. It's discretionary. They can just say, you know, we're not going to say if you're right or wrong. We just don't have time for this, and they can just deny your writ of certiorari. In Nevada, there's I think there's an extra caveat in Nevada. They will only hear, as far as I understand, a writ of certiorari from a district court appeal if the issue that you're challenging is that the justice court didn't have jurisdiction to do whatever it did. So this is a little bit complicated, but apparently you cannot challenge a district court's mistake in handling your appeal if it's just some run-of-the-mill garden variety legal mistake that they made. It has to be a jurisdictional issue that was at stake in the justice court for the Supreme Court to hear it on certiorari. That's just in Nevada. In the federal courts, my understanding is that that's just the way you get to the Supreme Court of the United States. Somebody will have a federal case in a federal courthouse. They'll file a appeal to the whatever circuit whatever appellate circuit that they're in. They'll lose their appeal in that federal appellate circuit, and then they have to get to SCOTUS, Supreme Court of the United States, using a writ petition for writ of certiorari. There's just no other way to do it. It's just how they do it in the federal courts. It's a whole different standard that applies there than applies in Nevada. And as I mentioned, these are just small snippets and little tidbits of information that I have from my research on these writs. I filed the writ of Mandamus is the only one that I filed in my own case, and I was published on it, so I have more of an understanding of how Mandamus works, but I do not by all means have a in-depth 100% know every nook and cranny of how it works. It's just, I'm just doing this video because people have asked over and over again, and I think it's time that I cover it because people want to know. Habeas corpus is used basically by criminals, convicts, or, you know, it could be used in other cases too, but that's the most popular use of the petition for writ of habeas corpus. Basically, they're challenging the authority of a whether it's a judge or I think it's actually filed against wardens, prison wardens, and like I said, there's other uses for it too, but this is the most popular, by a prisoner who's trying to argue that they're being held against their will and that they want the warden to show cause as to what authority they have to hold them. It ends up being more complicated than that. Prisoners end up bringing up a variety of issues in that petition, such as that their lawyer was ineffective and that they got convicted because they had a crappy lawyer. I'm not going to go into all of it. I just want people to know that that's what the habeas corpus petition is used for primarily. It may be you may be able to use it in other situations where somebody is being detained unlawfully and you want them produced before the court, and that whoever it is detaining them to give the court the authority, whatever it is that they may have, as to why they're detaining that individual. Quo Warranto, I'm not going to go into. Look, I don't have no idea what that one does. I have seen it I've seen the words, and I have not looked at all into it, but I know that that's one of the extraordinary writs. At this point, I think I'm going to go ahead and end this video. Off the top of my head, I really don't have anything else to bring up except there's no statute of limitations on writ petitions, so you have conceivably a little bit more time to think about before you file them, whereas an appeal, at least in Nevada, there's a 30-day time limit. The filing fee of on a writ petition appears to just be $250, which does in a way make it cheaper than an appeal, because an appeal you have to pay the filing fee of $250 and you also have to pay a $500 cost bond, which you can get back, but which I usually got back. In fact, every single time I got it back. I've always got my cost bond back, so I guess it's not a big deal. It is annoying to have to pay it up front though and wait years to get it back. With a writ petition, you don't have to deal with that. Bypassing the district court. You can bypass the district court if you're bringing to their attention purely legal issues, and it is not that often that comes up. And what I mean by purely legal is that there aren't any facts for the court to make findings on, or there aren't any findings of fact that the court needs to make. And so, I mean, honestly, I wouldn't do that if I was you. If anyone here is thinking of just going straight to the Supreme Court, the only way that you can really safely do that is when you're challenging a district judge's order, as I mentioned in all the previous examples. And the only reason that is really true is because you can't have one district judge issue an extraordinary writ against another district judge. They're on the same level. It's kind of like, that doesn't make any sense. If anyone's going to tell a judge what to do, it's going to be a judge from a higher court, not a judge from the same level. I really don't have anything else to cover in this video. It's a big video, 22 minutes and counting. If anyone here has any experience with writ petitions, go ahead and post them in the comments below, and I'm curious to see if anyone has had the same amount of success that I've had, as I had in my case that went to a publication. I suppose I'll go ahead and post that in the description below in case anyone wants to read about my writ petition and what happened in it. So with that, I'm going to go ahead and end this video.